Worship, we are on record. The state reports the matter has stood down for lunch break. The state is ready to proceed to worship as a court.
Yeah, thank you, sir. Is there a reply?
Yes, thanks. Thank you. Thanks, Your Worship. We will not respond in detail to everything that my learned colleague have said, because we feel that our case remains unshaken as we earlier addressed the court. Safe to say that the legal principle in respect of the doctrine of common purpose hasn't changed, notwithstanding that there's been further additions in the SNAE matter. And the case of the state versus Katleho, M. Arohanye, and Temba Shabalala and against the state, it's in the High Court of South Africa, Gauteng Local Division. It does bind this court. Your Worship, should there be reservations about applicant number 2 residing at the address? She has few addresses around in Gauteng, which addresses won't furnish in court yet. It will be furnished to the investigating officers. It is our submission that the applicants have made out a case successfully to be admitted to bail. I thank you.
Thanks, Your Worship. I'll just be short, Your Worship. Your Worship, the state said that accused number 3 might tamper with evidence. I'm still wondering that what type of evidence is still at the scene at this stage, Your Worship. We are on the second month, Your Worship. Is this state taking this matter seriously, Your Worship? That's the question that I'm asking myself, Your Worship. Another issue again, Your Worship. Accused number 3, he joined these 2 accused. There was no complaint from any state or any witness that is trying to intimidate or conceal any evidence. And he had the chance to do that while he was outside, Your Worship, if he wanted to do so, Your Worship. And then, Your Worship, I heard the state say that the accused number 3, he misled the community by saying that he was not on duty. How? I was being honest. He was not on duty. He never misled the community, Your Worship. Your Worship, another aspect that I will touch to is the issue of address again. Your Worship, accused is serving a fixed address. He's serving a property. Address in the Pope is still an address at the Your Worship. As long as it's existing, it's still an address. Address in which a place the accused is renting, Your Worship, it's still an address, Your Worship. We submitted that serving a furniture which worth 100,000, Your Worship. That evidence was never disputed, Your Worship. It still stands, Your Worship, before this court, Your Worship. And then, Your Worship, he's serving a patient. He was employed in the government, Your Worship. Your Worship, so the issue of address is out, Your Worship. And then the last issue, Your Worship, the state alleged that the evidence before this court is accused number 1 said shoot. But now, Your Worship, when my colleague addresses this court, Your Worship, he said no. Accused number 1 said no. Shoot the court to this innocent victim on the day in question. That's not the part of the evidence which was alleged, Your Worship. The evidence said, which was before this court, it says the accused number 1 said shoot. Shoot to who? That was the question to be asked, Your Worship. That's all, Your Worship, that I want to address before this court, Your Worship, as a please the court, Your Worship.
You see, the state raised one aspect which I find to be important, in that he argues that I can't overlook public outrage and anger of the community at large with regard to the death of this young boy. What is your comment? That It's one important aspect which the court must take into account.
I agree with the court fully, Your Worship. Your Worship, I will speak on behalf of applicant number 3.
Yes.
It is confirmed by my learned colleague here that he's having an address in Limpopo, in which he can be safe on that address. He can come and attend before this court while he's staying in Limpopo, outside the community of El Dorado Park. As the court pleases, Your Worship.
Thank you. Do you have any comment regarding the question of public outreach?
There should be the issue of public outrage. It needs to be looked within the context of the law. Because, Your Worship, we are a law-governed society. The community has to be told that when accused are charged for an offense, it doesn't mean they are guilty. They are presumed innocent. That is in terms of the provisions of Section 35 of the Constitution. So, having alleged to have committed an offense, it doesn't mean that automatically the person is guilty. The person could still be discharged by a trial court at a later stage. I know this court can't be used by other courts as a precedent setting, but, Your Worship, it will be extremely unfair if on the basis of the law all the elements show that the accused could be admitted to bail, but say for the fact that the community is going to take the law into their own hands and therefore the condemned decides to refuse the accused bail, Your Worship. Your Worship, we have made a successful case. We are of the view that notwithstanding what has been demonstrated at El Dorado Park by the community, the applicant deserves to be admitted to bail. We have said the state case is weak against them. They now know what actually happened. In fact, in my first appearance, when I came into the matter, on the second appearance of the matter, when the matter was adjourned, the court may not have heard it. Ourselves, as court officials, we heard it. Members in the public screamed, "Speak up, lady. Speak up, lady. We want to know the truth. The community is behind you." It was said in the court day in court 10. Now, so the element of the community marching in respect of this matter, as for my client, it will not relate to her, Your Worship. It is on that basis, therefore, that I feel strongly that the court should admit her rather to bail. I thank you.
It's unfortunate I won't be able to deliver judgment now. There's so much that has been presented before me.
Yes.
And Mr. Lisha is asked to be excused. I think Monday, is it, are you available for me to deliver the judgment? You see, I was going to suggest Friday. Unfortunately, I'm not available on Friday.
Your Worship, I'm in regular contact with attorney for accused number 1. I will communicate with him regarding the date for Monday. That suits me. I'm not so sure how my colleagues have.
I will speak with your learned friend, Your Worship, in Indonesia. I have a judgment in court through, Your Worship, in Indonesia. So I will try to make some arrangement with him, Your Worship. Unless if maybe he can attend me early in the morning, Your Worship, I don't have any problem. Or my colleague will stand in for me, Your Worship.
Oh, I see.
Yeah, for the judgment, Your Worship.
Oh, I see. That's fine. Stand up. Against. You may stand up. Matter is adjourned until the 28th September. It will be for judgment. All three in custody. You won for court 10 at 8:30.
As a court decision.
This is Your Worship.
As a court decision.
Court shall adjourn.
The presiding magistrate, Magistrate Malasela Mhago, saying he will deliver his judgment in terms of that bail application of the 3 police officers who stand accused of killing 16-year-old Nathaniel Julies from Eldorado Park to Monday at 10:30. So they will still be remanded in custody and will only know whether they will be allowed to get bail on Monday. Simon Ndelvane, Kayleen Whiteboy, Foster Nechio Ngolo stand accused of killing Nathaniel Julies, and Kayleen Whiteboy saying that she's been a police officer for a year and she did not intend to kill the 16-year-old Nathaniel Julies. When she fired that shot, she was just merely acting on instruction. My colleague Aviwe Mtila has been following developments with that story. I'm going to touch base with him in a moment just to give you an idea of what played out in court before these proceedings.